Welcome back. So we will talk about now at topic 7. We're going to talk about withdrawal from representation, and we will start with section 3.7 of the Code of Conduct for BC lawyers. Let me start by reading 3.71. A lawyer must not withdraw from representation of a client except for good cause and on a reasonable notice to the client. Several interesting commentaries there. Uh, let's start with the first two ones. Number one, although the client has the right to terminate the lawyer-client relationship at will, a lawyer does not enjoy the same freedom of action. Having undertaken the representation of a client, the lawyer should complete the task as ably as possible unless there is justifiable cause for terminating the relationship. It is inappropriate for a lawyer to withdraw on capricious or on arbitrary grounds. So as you can see, there's an imbalance here between the rights of the client to withdraw, to terminate their services, and your right to withdraw from representation. The client can do it at will. The way you act must be for a good reason. Second commentary, an essential element of reasonable notice is notification to the client unless the client cannot be located after reasonable efforts. No hard and fast rules can be laid down as to what constitutes reasonable notice before withdrawal, and how quickly a lawyer may cease acting after notification will depend on all relevant circumstances. One situation that occurs often in immigration law is that you have to provide documents to the government on behalf of the client. You received a letter or an email from the Canadian government or a provincial government saying, we give you 60 days or 30 days to provide this document. So this is very important to always make sure you have the right email address and you can communicate with your client, because sometimes you will be several months without receiving any communications from the immigration authorities, and now boom, they gave you 30 days to provide some documents. So you must be able to locate your client at all time. And if you're going to withdraw and or you can't find a client, you have to make sure you don't put the client in a difficult position like this if they have to provide additional information to the client, to the immigration authorities. So that's very important to keep in mind. 3, every effort should be made to ensure that withdrawal occurs at an appropriate time in the proceedings in keeping with the lawyer's obligations. The court, opposing parties, and other directly affected should also be notified of the withdrawal. So that's one of the situations that I just mentioned, like you can't put the client in the difficult position if you say something like, well, I'm withdrawing and, we're 10 days or 12 days away from providing important documents. That would place the client in an impossible position. So there's a lot of downtime in an immigration file. So don't do it especially not on purpose, knowing the client is under pressure to provide documents and you choose that very moment to withdraw your representation. So that would probably violate your ethical obligations as an immigration lawyer. Another one that I'd like to bring to your attention is when you leave a law firm. When a lawyer leaves a law firm to practice alone or to join another law firm, the departing lawyer and the law firm have a duty to inform all clients for whom the departing lawyer is the responsible lawyer in a legal matter, that the clients have a right to choose who will continue to represent them. The same duty may arise when a firm is winding up or dividing into smaller units, and that's a situation that can occur. Again, a lot of permanent resident applications, for instance, the process can last several years. The practice of law being what it is, you may change law firm, you may decide to go on your own. So you have to make sure that you and the law firm send clear communications to the client to say, look, I'm leaving this law firm, and the client always have the option to remain with the law firm or to choose other representation or to go with you. But you must make sure you have a good paper trail and you do everything in writing, and the clients are informed of the situation, so they make an informed decision to either stay with you as a lawyer or stay with the law firm they're with. They'll be assigning another lawyer, or just say, we're going with completely separate representation. But make sure you and the law firm, before you consummate that separation, have all the paperwork in order to have clear instructions from the client. Optional withdrawals. Sometimes the withdrawals, you have to withdraw from a situation. Remember when we talk about conflicts of interest, if a conflict cannot be resolved or it can impact your way of representing a client, some withdrawals are optionals, and this is what we're going to talk about here. If there has been a serious loss of confidence between the lawyer and the client, the lawyer may withdraw. So it's not an obligation. Maybe that confidence can be restored, but that's an option that you have as a lawyer to withdraw at that time. Non-payment of your fees. If after reasonable notice the client fails to provide a retainer or funds on account of disbursement, may use to withdraw from a situation, withdraw from representation. We saw the optionals one. There are situations where you must withdraw. 3.77, a lawyer must withdraw if the lawyer is discharged by a client persists in instructing the lawyer to act contrary to professional ethics, or C, the lawyer is not competent to continue to handle a matter. So in these three situations, it's not an option. You must withdraw from representation. And as we will see now for immigration consultants in the ICCRC Code of Professional Ethics, there are very, very similar provisions. And if we look at Article 11, page 10 of the Code of Professional Ethics, we looked at the retainer agreement regulation. Now we're back to the Code of Professional Ethics, Article 11. A member shall withdraw as the client's representative if the member, the immigration consultant, is discharged by the client, instructed by the client to do something illegal or in contravention of this code. 3, the member's continued involvement will place the member in a conflict of interest. 4, the member is not competent to handle the matter. So we see that for the mandatory withdrawals, very, very similar. The obligations of the immigration consultants are very similar to the ethical obligations of lawyers in BC. Let's talk about optional withdrawals for immigration consultants. A member may, but is not required to, withdraw as the client's representative if there has been a serious loss of confidence between the member and the client, including if the client has deceived the member, the client has failed to give adequate instructions to the member, or the client has failed to accept and act upon the member's advice on a significant point. Same thing for failure to pay. So as you can see, again, very similar in these situations, loss of confidence, failure to get paid, it's an optional withdrawal. The member, the immigration consultant, as it is the case for immigration lawyers, may withdraw, but it is not an obligation as we saw earlier. So it might be a good idea as an immigration consultant and also as an immigration lawyer to have these provisions in your retainer agreement. So really from the get-go, the client understands in which situation you will have to withdraw and in which situations that you will have the option to withdraw. So maybe not all these provisions, but at least make the client understand in your retainer agreements in which situation you may have to terminate your professional relationship with the client. So that could help, show that you've been fair and reasonable if it comes to that. And again, with immigration law, we deal oftentimes, and most of the times, to people who have very, very little experience of Canadian law. So it could be a good idea to include some of these provisions in the retainer agreement. So these clients with little experience of the Canadian legal world, and sometimes their English is not great. So make sure they understand, make sure that you have interpreters and translators that they can understand these provisions in your retainer agreement. So that completes topic 7, and we will be back to you in a few seconds.